बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूअर्स, मैं हूं मलिक फयाज बर्ड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरा यूट्यूब चैनल। मेरी उम्मीद करता हूं आप तमाम दोस्त सब खैरियत होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। आज हम शुरू करेंगे पाकिस्तान पीनल कोड के सेक्शन 465 से। चलिए शुरू करते हैं। अल्लाह। सेक्शन 465 प्रोसीजर इन केस ऑफ पर्सन व्हेन सेंट फॉर ट्रायल बिफोर कोर्ट ऑफ सेशन और हाई कोर्ट, कोर्ट बीइंग lunatic. Number 1, if any person before a court of session or a high court appears to the court at his trial to be of unsound mind and consequently incapable of making his evidence, the court shall in the first instance try the fact of such unsoundness and incapable, and if the court is satisfied of the fact, it shall regard a finding that effect and shall postpone further proceedings in the case. Section 466 Release of lunatic pending investigation or trial. Incapable of Number 1, whenever an accused person is found to be of unsound mind and incapable of making his defense, the magistrate or court, as the case may be, whether the case is one in which bail may be taken or not, may release him or on sufficient security being given that he shall be properly taken care of and shall be prevented from doing injury to himself or to any other person, and for his appearance when required before the magistrate or court or such officer as the magistrate or court appoints in his behalf. Number 2, custody of lunatic. If the case is one in which, in the opinion of the magistrate or court, bail should not be taken, or if sufficient security is not given the magistrate or court, as the case may be, it shall order the accused to be detained in safe custody in such place and manner as he or it may think fit, and shall report the action taken to the provincial government, provided that no order for the detention of the accused in a lunatic asylum shall be made otherwise than in accordance with such rules as the provincial government may have made under the Lunacy Act 1912. Section 467 Resumption of inquiry or trial. Whenever an inquiry or a trial is postponed under section 465, the magistrate or the court, as the case may be, may at any time resume the inquiry or trial and require the accused to appear or be brought before such magistrate or court. Number 2, when the accused has been released under section 466 and the sureties for his appearance produce him to the officer whom the magistrate or court appoints in this behalf, the certificate of such officer that the accused is capable of making his defense shall be received receivable in evidence, section 468. Procedure on accused appearing before magistrate or court. Number one, when accused appears or is again brought before the magistrate or the court, as the case may be, the magistrate or court considers him capable of making his making his defense, the inquiry or trial shall proceed. Number two, if the magistrate or court considers the accused to be still incapable of making his defense, the magistrate or court shall again act B, and if the act according to the provisions of section 464 or section 465, as the case may be, and if the accused is found to be of unsound mind and incapable of making his defense, shall deal with such accused in accordance with the provisions of section 466. Section 469. When accused appears to have been incensed, when the accused appears to be of sound mind at the time of inquiry or trial, and the magistrate or court is satisfied from the evidence given before him or it that there is reason to believe that the accused committed an act which, if he had been of sound mind, would have been an offense, and that he was at the time when the act was committed by reason of unsoundness of mind. Incapable of knowledge the nature of the act, or that it was wrong or contrary to law, the magistrate or court shall proceed with the case. Section 470. Judgement of acquittal or ground of lunacy. Whenever any person is acquitted upon the ground that at the time at which he is alleged to have committed an offense, he was by reason of unsoundness of mind incapable of knowledge the nature of the act alleged as constituting of mind in of the offense, or that it was wrong or contrary to law. The finding shall state specifically whether he committed the act or not. Section 471. Person acquitted on such ground to be detained in safe custody. Number one, whenever the finding states that the accused person committed the act alleged, the magistrate or court before whom or when the trial has been held, if such act would, but for the incapacity found, have constituted an offense, order such person to be detained in safe custody in such place and manner as the magistrate or court think fit, and shall report the action taken to the provincial government. provided that no order for the detention of the accused in a lunatic asylum shall be made otherwise otherwise than in accordance with such rules the provincial government may have made under the lunacy act 1912. Number 2, powers of provincial government to relieve inspector general of certain functions. The provincial government may empower the officer in charge of the jail in which a person is confined under the provisions of section 466 or his section to discharge all or any of the lunactions of the Inspector General of Prison under Section 473 or Section 474. Section 472 REP by the Lunacy Act 1912 Section 101 and Schedule 2nd. Section 473 procedure where lunatic prisoner is reported capable of making his defense. If such person is detained under the provisions of Section 466 and in the case of person detained in all jail, the Inspector General of the prisons or in the case of person detained in a lunatic asylum, the visitor of such asylum or any two of them shall certify that in his or their opinion such person is capable of making his defense. He shall be taken before the magistrate or court as the case may be at such time as the magistrate or court appoints and the magistrate or court shall deal with such person under the provisions of Section 468 and the certificate of such Inspector General or visitors as aforesaid shall be receivable as evidence. Section 74. Section 474. Procedure where lunatic detained under Section 466 or 471 is declared fit to be released. Number 1, if such a person is detained under the provisions of Section 466 or Section 471 and such Inspector General or visitor shall certify that in his or their judgment he may be released or to be detained in custody or to transferred to a public lunatic asylum he has been already sent to such an asylum, and in case it orders him to be transferred to an asylum, he appointed a commission consisting of a judicial and 2 medical officers. Number 2, if the commission shall make formal inquiry into the state of mind of such person, taking such evidence as is necessary, and shall report to the provincial government, which may order his release or detention as it thinks fit. Section 475. Delivery of lunatic to care of relative or fraud. Number 1, whenever any relative or friend of any person detained under the provisions of Section 466 or Section 471 desires that he shall be delivered to his care and custody, the provincial government may, upon the application of such relative and friend, and on his giving security to the satisfaction of such provincial government, that the person delivered shall a. be properly taken care of and prevented from doing injury to himself or to any other person, and 2. Number B. Be produced for the inspection of such officer, and it shall such time and at such time and places as the provincial government may direct, and see in the case of a person detained under Section 466, be ordered such person to be delivered to such relative or friend. Number 2, if the person so delivered is accused of any offence, the trial of which has been postponed by reason of his being of unsound mind and incapable of making his defense, and the inspecting officer referred to in subsection 1 class B certifies at any time to the magistrate or court that such person is capable of making his defense, such magistrate or court shall call upon the relative or friend to whom such accused was delivered to produce his being before the magistrate or court, and upon such production the magistrate or court shall proceed in accordance with the provisions of Section 468, and the certificate of the inspecting officer shall be receivable as evidence. Next chapter, proceedings of case. Proceeding in case of certain offences affecting the administration of justice. Section 476. Section 476. Procedures in case mentioned in Section 195. Number 1. When any offence referred to in Section 195 subsection 1 class B or class C has been committed or in relation to a proceeding in any civil, revenue or criminal court, the court may take cognizance of the offence and try the same in accordance with the procedure prescribed for summary trials in इस chapter में when number 2, when in any case tried under subsection 1 the court finds the offender guilty, it may notwithstanding anything contained in subsection 2 of section 262 A. Pass any sentence of the offender authorized by law for such offence except a sentence of death or imprisonment for life or imprisonment exceeding 5 years. If such court be a high court, a court of session, a district court or any court exercising the power of a court of session or a district court, B. sentences the offender to simple imprisonment for a term which may extend to 3 months or to pay a fine not exceeding 1000 rupees or both if such court be a court of a magistrate of the first class, a civil court other than a high court, a district court or a court exercising the powers of a district court or revenue court not inferior to the court of collector. C. Sentence the offender to simply imprisonment for a term not exceeding 1 month or to pay a fine not exceeding 50 rupees or both of such court be a criminal court or revenue court other than a court referred to in class A or class B. Number 3. The powers conferred are civil revenue and criminal court under this section may be exercised in respect of any offence referred to in subsection 1 and alleged to have been committed in relative to any proceeding in such court by the court to which such former court is subordinate within the meaning of subsection 3 of section 195. Number 4. Any person sentenced by any court under this section may, notwithstanding anything herein before contained, appeal. A. In the case of a sentence by the High Court to the Supreme Court. B. In the case of sentence by a court of session or district court or a court exercising the powers of a court of session or district court to the High Court, and C. In any other case to the session judge. Number 5. The provisions of chapter XXX1 shall so far as there are applicable apply to appeal under this section, and appellate court may alter the finding or reduce or enhance the sentence appealed against. Section 476A. Forwarding of cases for trial by court having jurisdiction. Number 1. If the court in any case considers that the person accused of any of the offence referred to in section 476 subsection 1 and committed in or in relation to any proceeding before it should not be tried under that section, such court may, after regarding the facts constituting the offence and the statement of the accused person, as here before provided, forward the case to court having jurisdiction to try the case, and may require security to be given for the appearance of such accused person before such courts, or if sufficient security is not given, shall forward such person in custody to such court. Number 2. The court to which a case is forwarded under this section shall proceed to hear the complaint against the accused person in the manner herein before provided. Section 476B, Section 477, 478, 479 omitted by Law Reforms Ordinance 1972, Atom 158. Section 480. Procedure in certain cases of contempt. When any such offence offences as is desirable in section 175, section 178, section 179, section 180 or section 228 of the Pakistan Penal Code is committed in the view of presence of any civil, criminal or revenue court. The court may cause the offender to the detained in custody and at any time before the rising of the court on the same day may, if it thinks fit, take cognizance of the offence and sentence the offender to fine not exceeding 200 rupees and in default of payment to simply imprisonment for a term which may extend to 1 month unless such fine to be sooner paid. Number 2, omitted by Act 2nd 1950 commentary section 481 record in such cases. Number 1, in every such cases the court shall record the fact constituting the offence with the statement, if any, made by the offender, as well as the finding and sentence. Number 2, if this offence is under section 228 the Pakistan Penal Code, the record shall show the nature and stage of the judicial proceedings in which the court interrupted or insulted was sitting and the nature of the interruption or insult. Section 482 procedure where court considers that case should not be dealt with under section 480. Number 1, the court in any case considers that a person accused of any of the offences referred to and in section 480 and committed in its view or presence should be imprisoned otherwise than in default of payment or fine, or that a fine exceeding 200 rupees should be imposed upon him, or such court is for any other reason of opinion that the case should not be disposed of under section 480. Such court, after recording the facts constituting the offence and the statement of the accused as herein before provided, may forward the case to a magistrate having jurisdiction to try the same and may require security to the given for the appearance of such accused person before such magistrate, or if sufficient security is not given, shall forward such person in custody to such magistrate. Number 2, the magistrate to whom any case is forwarded under this section shall proceed to hear the complaint against the accused person in manner herein before provided. सेक्शन 483 बाकी इंशाल्लाह हम कल पढ़ेंगे। तो आखिर में मेरी आप तमाम दोस्तों से गुजारिश है कि मेरी अगर वीडियो अच्छी लगी है तो मेरे इस चैनल को सब्सक्राइब कर देना, लाइक कर देना और मेरी वीडियो को पूरा वॉच करना है। आप तमाम दोस्तों का बहुत बहुत शुक्रिया। अल्लाह आपका निगहबान हो। पाकिस्तान जिंदाबाद।